Assalamualaikum warahmatullahi wabarakatuh. I am Nasha Dzulaikha binti Dzulkarnaen with matrix number of 2010984, and my other two groupmates, which are Nur Adiba Anthassya binti Muhammad Sin with matrix number of 2015116, and Hilman Othman bin Muhammad Arfah with the matrix number of 2016279. Hello and Assalamualaikum to Prof. Mushira and other classmates, and this video is about our project on the topic of blogger defamation. So the article that we have chosen is the article of Vivi Yusof files a defamation suit against social media user over B40 and M40 remark by Malay Mail. So the problem statement is the act of posting defamatory words is equivalent to blogger defamation if all the elements of defamation is fulfilled. The elements are: words must be defamatory, words must refer to the plaintiff, and words must be published. Posting in social media could lead to the act of blogger defamation if the words are contradicts with the Defamation Act 1957. And the issues that we have inferred include whether the statement that was posted by the defendant, which is Alia Najwa Hasanuddin, constitute defamation. The second one is whether the defendant is entitled to defenses. So next, I will pass to Hilman Othman to explain further about the case laws that are related to our topics.
Assalamualaikum, my name is Hilman Othman bin Muhammad Arfah, and I will be presenting the case law relating to the topic of blogger defamation. So there's two cases that we chose for the topic is Datuk Sri Anwar bin Ibrahim against the New Straits Times Press Sedia Berhad and another, and YB Haji Khalid bin Abdul Samad against Datuk Aziz bin Isham and another. Moving forward to the summary of the case. So the summary of the case, Datuk Sri Anwar Ibrahim was former Deputy Prime Minister and former Minister of Finance, and the defendants were writers, printers, publishers and distributors of the New Straits Times newspaper. On 2nd March of 2002, the defendant published in this newspaper an article captioned that Anwar's link to US lobbies and new revelation by a political weekly magazine into Datuk Sri Anwar Ibrahim ties with a controversial US lobby group in Washington DC. The plaintiff claimed that the article was defamatory and sought general damages of 100 million and as well as aggravated and exemplary damages. The defendant resisted the claim on the grounds that the article was not defamatory and that even if it was, they were entitled to the defense of qualified privileges. Moving forward to the judgment of the case, the court held that by allowing the plaintiff's claim with cause that it was safe to conclude that the effect of the article would certainly lower the plaintiff in the estimation of ordinary, right-thinking members of Malaysian society, and they would occur some degree of hatred, contempt and ridicule to the plaintiff. And the court also held that general privilege known as the reportage will only apply in certain cases, which is ongoing disputes where allegations of both sides are being reported. The allegations must be reported fair, disinterested and only in neutral way. So therefore, even if it was a reportage, there was only one version of one side. So the tort of defamation exposed the defendant to a monetary remedy that include both vindications of the plaintiff to the public and as consolation for him for a wrong done. The vindication of the plaintiff standing in the community should be focused of the remedy rather than any award of large sums of money for the plaintiff's hurt feelings. There was no evidence that the plaintiff had experienced any economic harm. Therefore, there was no rationale for awarding substantial damages. A sum of 100,000 was thus awarded as compensatory to the plaintiff. Moving forward to the second case, the plaintiff is a member of Parti Islam Malaysia PAS and a member of Parliament for Shah Alam and sued the defendants for libel. The first defendant was sued in his capacity as chief editor, and the second defendant was a publication. The second defendant had republished in a total article that appeared in the official blog that another MP had portrayed the plaintiff as a person who was capable of distorting verses from the Holy Quran for his own political end. The article was made in connection with the plaintiff's role in attempting to resolve a dispute over a relocation of Hindu temple in Section 23 Shah Alam, which has stirred up emotions amongst residents. That the defendant said that the article did not make any direct reference to the plaintiff, was not defamatory of him, and they relied inter alia on a defense of qualified privilege. They said that they merely republished an article that was already posted by another MP on his official blog, and the same privilege that attached to the article is the first publication on the blog extended to protect its republication by the second defendant. Moving forward to the judgment of the case. So, the court allowed the claim and awarding the plaintiff 70,000 in compensatory damages and costs. The verse quoted from the Holy Quran in letter written by the plaintiff to the resident of Section 23 were confirmed by the PW2 to be accurate, and the defendant made no attempt to verify the veracity of the article, and there was no disclaimer published to make known to its reader that the views expressed in the article were those of the MP of the blog and not that of the second defendant. So the court rejected the argument that the article was extracted from the official blog of the another MP, and the defense of the reportage or responsible journalism raising qualified privilege was not applicable to this case. The defense of ancillary derivative privilege was rejected as the article that appeared on the blog of the official website of the MP did not attract qualified privileges. In discussing the legal issues on this case, Vivi Yusof as the plaintiff and Alia Najwa Hasanuddin as the sole defendant, it is essential for us to see and to fulfill all elements under defamation, which is words must be defamatory, words must refer to the plaintiff, and words must be published, which the legal issue for this case is whether the statement posted by the defendant on Facebook constitute defamation. The first element of defamation has been established in this case, since the defendant claimed that the plaintiff had uploaded a statement that mentioned and questioned the government's action in helping the B40 and M40 groups, despite not contributing to the country's economy, and was arrogant, can be considered as defamatory words. This is because the plaintiff can never be proven that such statement has been arised by her, and there is no proof that the plaintiff have said that. The defamation type that has been done by the defendant is libel. This is because the Facebook page statement is equivalent to a defamatory statement which is contained in permanent form. In the case of YB Haji Khalid bin Abdul Samad against Datuk Aziz bin Sam, the judge allowed the claim of the plaintiff, stating that the plaintiff has suffered hatred from the community, saying that he had raised a serious topic relating to the Muslims and Hindu. Going back to the current case, the words have affected the plaintiff's reputation and also has caused her to be demanded for dismissal from the University Technology Mara Board of Directors. Moving forward to the second legal issue, second element, it can be established that the defamatory remarks in the question were made referred to the plaintiff. The statement posted by the defendant on the Facebook and Instagram account had clearly shown that all the statements made were referred to the plaintiff. In the case of Datuk Sri Anwar bin Ibrahim and against the New Straits Times Press, when the court found that the article published clearly stated the name of the plaintiff, it had fulfilled the second requirement, which is there is no other people which is described in the article than the plaintiff itself. Therefore, in this case, the defendant has no ways to prove that that the post published is not about the plaintiff, while it has clearly stated the name and pictures of the plaintiff. Third, For the third element, the defendant had uploaded several defamatory statements on her Facebook and Instagram account. This has proven the publication on the internet, which is the material that has been published onto the internet. Hence, it can be concluded that defamatory words towards the plaintiff have been published by the defendant. And second legal issues, whether the defendant is entitled to any defense. The defendant may bring an in defense of apology to reduce the damages that done by her. In Section 10, Clause 1 of the Defamation Act, this section provides that the defendant may offer an apology in mitigation of damages to the plaintiff if he or she has the opportunity to do so. The defendant may bring defences to help her during the trial, referring to the Section 8 of Defamation Act of 1957. It had provided that the defendant can defend herself by making a justification, and the defendant could prove the truth of the receipt of favours and could not do so in relation to the favours of money. If the defendant wanted to prove that she is not guilty, she can use justification as her defence because it is actually a full defence. In justification, she needs to prove the words of defamation is proven to be true, which means in this case, she needs to prove that she stated and claimed that of Bibi Yusuf is the truth and there is no flaws in her statement that was given. In the case of Datuk Sri Anwar bin Ibrahim against the New Straits Times Press, the judge concluded that the defendant had no ways to defend and when there is no plea of justification was entered or pursued, the failure of the defendants to verify the accuracy of the material published, as well as their failure to seek a response from the plaintiff that led to the unavailability of the defence of qualified privilege in relating back to this case. If she can prove the statement that was brought up by the plaintiff is true, it means that she has succeeded in her defence.
As for the next part, we will be discussing about the journal article entitled Media and Communication Ethics, Legal Perspective and the Public Expectation 2019, One Malaysian Law Journal. This journal discusses about the liability of the bloggers in the context of Malaysia. Now we will look into the concept of blogger defamation in Malaysia.
In the case of Datuk Sukri bin Haji Muhammad and Wan Muhammad Azri bin Wanderis, if it involves blogger, one can still sue the blogger who owns the website. In this case, the respondent owned and administered his blog or website known as the said blog. The appellant contended that the respondent had uploaded and published 3 articles in the blog which defamed the appellant. Malaysian bloggers Jeff Uy and Ahiruddin Atan Rocky were sued by the New Straits Times Press Malaysia and some members of NST for defamation. In the interim injunction granted by the court on 11 January, Uy was ordered to remove 13 postings from his blog within 7 days. This was the result of an interim ex parte injunction to refrain from further posting of articles against the plaintiffs. Posting hyperlinks of materials which may defame a person may also make the blogger liable for defamation depending on the circumstance, if the person who posts it can have control over the publication of it. In the case of Stamlife Berhad and Bristol Myers Squibb, Sendirian Berhad and another, the plaintiff's claim against the defendants was for libel based on numerous messages, including a hyperlink to an external blog created and posted by the users of the first defendant's website forum. So, can bloggers be held liable for the things posted by the third parties? In Ko Wai Piao v Chong Chien Jen, the court in this case held that knowledge on the part of the respondent could not be proved. He did not know and hence there was no way for him to consent the publishing of the article. The gist of this case is that the blogger did not have knowledge and had not consented to the publishing of the material in his blog, which was posted by a third party, then the blogger would not be held liable for it. So in conclusion, sometimes people are in a dilemma whether to publish the truth about certain issues or hide them from the public for an array of reasons. What is certain is that they are expected to adhere to media laws, communication laws, and media ethics in order to avoid legal implications. Media can still rely on many defenses available in the relevant laws, including seeking public apology through retraction of statement that was made earlier. Bloggers are responsible under the existing legal framework of the country. There is no doubt about this. However, the problem is that there is no official registry to register the bloggers. Malaysia is lacking a regulatory framework to govern the conduct of bloggers. The most feasible way to solve this problem is by enacting a code that provides the rights, duties and liabilities of a blogger. By following a uniform code of ethics in the blogosphere, bloggers would have integrity. Other than that, it can also prevent anonymous bloggers from tarnishing someone's image.
That's all from our group. Thank you.